and the parties are essentially responsible for the child while the child is with them. So you had to give us a couple of moments. Unless you have redaction ability, Brett, and you can take out the names and stuff and show it for the person. I know text is going to come up, but let's do this. So let's go on. Is there anything that's ambiguous about the Alvarez seeing holding for you, Brett? Anything is ambiguous about that, or is it pretty clear?
Hold on a second.
Can you all see that?
Yeah, right. No, that's very straightforward.
And even in back homes, right?
Yep.
So if I didn't sue State Farm, Austin Road Basketball, Dr. John Shem, Shem Medical, Shem Spine, and actually I don't sue the VA, right? I sue who? The United States, right? Because the VA is an agency of the United States. And everybody working under that is subject to what? The United States. It's not necessarily a respondent superior, plus you can't really sue the United States for anything other than declaratory judgment. For the most part, unless they waive it, which they're probably not going to. We know they're not really very flexible with certain things. But so if I did not sue specifically for that issue, the trial court can't tell me I can't go and sue everybody for something that's not related to what happened on January 16, 2017. That's the only thing that matters. What happened on January 16, 2017 while I was stationed or sitting at a stale red light, obeying the laws of Florida, when at the same time and place, Chandra Denise Tucker operating the vehicle recklessly rammed into the rear of the Kia that I occupied. That's it. And her admitting that she did a rolling stop, I would think would constitute something that would give me grounds to bring punitive damages. But hell, this particular judge chose not to agree, which is kind of crazy. The lady said it several times, and I'll pull it up for you where she says it's a rolling stop. So, but at any rate, there you go. Not properly before the court, and that may go, homie, why I didn't get her when she said based upon the record. Well, what record? You told me to go and release parties that weren't parties to the case. And I'm gonna say this: I believe that the system is proper. I think the stewards of the system tend to do things that they probably shouldn't do, and that's where it's up, and that's where the onus falls on the individuals to move forward in your situation and address your matters. Now, the fraud. Hold on, let me take out and go to Texas so they don't trip. I'm trying to get my man Big X or one of them ghetto boys on. And there you go, Texas, where a court cannot adjudicate upon the rights of parties not brought before it without giving them an opportunity to be heard. Texas may be a little bit more specific, maybe as to the question. A court cannot render a binding judgment concerning matters over which it has no subject matter jurisdiction. And subject matter jurisdiction in interstate, this comes up, is determined by reference to the UCCJEA set out by Family Code 152. Whether or not a court has subject matter jurisdiction is a question of law, which we review de novo. But actually, any question of law, any circuit court or any appellate court would review brand new.
All right, so Greg, why don't you put that in context?
You mean an issue of law? I mean, like the law says this is what the court's supposed to do, and the court does not do that, or your arguments the court did not do that, or the court may have misapprehended the law. When you appeal it, the appealing court would say, hey, this is an issue of law. Does the court have the authority to rule or force somebody to do something for a party that is not properly before the court? In other words, does the court have personal jurisdiction over the non-represented parties? And in fact, I think you may also have an issue depending on how the circumstances roll is the party who is actually presenting the pleading and defending the pleading doing that properly, because that could bring up an issue of sanctions and what have you, which is what they tried to say to me. But one part about being sanctioned is they have to have some standing in fact. But to your question is, don't laugh. There has to be something in fact that they're using to substantiate their ruling. In theory, that's supposed to happen. And what we're reading is not just theory; these are case holdings. But that's how it should come up about. When it doesn't, again, it falls upon us to do what's necessary to appeal whatever's going on.
All right, now explain that in a language that doesn't require fluent legalese.
In other words, if the court ain't do right, the appeals court is supposed to slap him down.
All right, so I'll give an example. So for me,